The mediation process, as we've talked about, is a give and take back and forth. And sometimes you may wonder, well, why is she making this move and this amount, and why are they only moving this amount? We seem to be moving more than they are. Well, that's sort of a mediation process. Once I know where we're trying to go, I am trying to make the moves to get us there. Now, at some point in the process, the opposing counsel may do what's called brackets, and it's if you move here, we'll move there. So let me just give you an easy math example. It's not an example of how these cases can settle or the value of the case, but I'm just doing some easy math for you. Let's say the carrier says, if you go to 100, I'll be at 50. The message is they want to try to settle the case generally for $75,000. That's what a bracket is. So they're setting their lower limit, setting their higher limit. And that will normally happen, in my experience, at about 4 to 5, maybe 6 moves into the mediation. We're feeling each other out. We're now starting to send messages about where we think the value of the case is. You may or may not be happy with that, but sometimes that's what the reality is. That's what they're willing to pay. And the question becomes whether you're willing to accept that amount to settle your case. That's a decision that I talk with you, as does the mediator, so that you can come to the decision that's right for you and your family. One of the things you do need to understand in the mediation process is that standard of review will really impact the value of the case. If it's a de novo case standard of review, the case is probably going to settle for more. If it is a arbitrary and capricious, the case is probably going to settle for less. And the other factor is the judge. In the Tampa-St. Petersburg area, we had a judge who basically, in the course of her career, maybe only awarded a dozen of these cases in favor of the policyholder. Those odds are pretty crappy, and the carrier knows their likelihood of success, and they're going to factor that in terms of the offer that they make to us in terms of settlement. Ultimately, you'll have to decide whether you want to settle or proceed to the next stage of litigation, which is called a motion for summary judgment. But before we get there, let's talk about the release that you may be asked to sign if the case is settled. And I don't mean if, you will be asked to sign. The question really is, what are the terms of the release?